Hello, fellow seekers. I hope everyone is doing well. I have an update on Chad Doerman. There was actually a couple months ago, but I was waiting for, I don't know, I was just waiting to see if another one would come up that y'all would really be interested in. And if you haven't heard it already, I think you will be very interested. The latest is, and this was I think this came out about 9 days ago. Chad Doerman now wants his confession tossed. I'm like, what? Two things were, and I'll share them. Well, I couldn't find one of them. One of them was the fact that Doerman wanted to appear in court without, I guess, shackles and to be able to wear street clothes, which I have seen, and it may show it in this video as well, seen him. And I guess they just, and I get it. I mean, I guess that's fair. And apparently they say he's been, well, I don't know if they said model prisoner, but I guess he hasn't caused them any difficulties since he's been in jail. So I think they are going to allow him to do that. Another interesting thing that they discussed was, the defense was to allow convicted felons that have served their time to serve on the jury. So that will be interesting. And there's a little bit on that too I'll share with you, but I wanted to get to this one because I thought this one was really the one, because most of us are probably going, great, the poor mom and the stepdaughter. I can't even fathom what they still must be going through. But the reason why they're saying this, and they'll of course explain it in better detail here, is that I believe they presented his Miranda rights to him, but he didn't sign them. And then I believe there were some disparaging remarks police made. Maybe one of them called him a monster, I think it was. But I'm thinking, due to the situation and what they had to come upon, I can't imagine. Oh, and there was another one. Well, I'll let you get on with it, but I think that is not going to be a problem. I think the main reason they're trying to do all of these things, like tossing out the confession and, getting convicted felons to serve as jurors, is that I think the evidence is overwhelming that Doerman did this. He even told them that he'd been thinking about it, I think 4 months prior. So it was premeditated. He'd been thinking about it for a while, but you know how they get in there and they get to the attorneys and things always change. But I think maybe what they're trying to do is to at least, because as we know, prosecution is seeking the DP for him. And I think that's why they're trying to do all of this, to at least maybe get the DP off the table. I mean, that's my guess. But I'll go ahead and share this with you.
Doermans Lawyers say he was interviewed by detectives and read his Miranda warnings, but never presented with a form outlining those rights and never asked whether he waived those rights. Doerman is quoted as saying, "Yep," when asked whether he understood that he had a right to an attorney. About 6 minutes into the interview with detectives, Doermans Lawyers claim he said, "I'll wait for a lawyer. I really don't know. Give me a couple of days. Let me talk to a lawyer so I can get good, nice answers for you." Detective Ross responded, "I understand. Do you have a lawyer?" Doerman responded, "We have family lawyers," and said that his father was a lawyer. Doerman's attorneys also claimed that social workers and medical personnel were used by detectives to question Doerman, and that he made incriminating statements that could be used against him. They also say that deputies called him a monster and talked about possibly shooting him, and that he should be placed in the cruiser so one deputy wouldn't do that. With me is Mark Weaver. He's a former Ohio Deputy Attorney General. He's also served as a special prosecutor in several death penalty cases. Mark, what are your first thoughts on this motion to suppress Chad Doerman's police statement?
I've litigated against this attorney, Greg Myers. He's one of the most experienced death penalty defense lawyers in the state. I know him well. We don't know what the prosecutor has to say about this motion, but I will say this. There is so much evidence against Chad Doerman that this motion to suppress is very key, because it's hard to see how the defense wriggles out of this one.
Why do you say it's very key? I mean, because there is a lot of evidence. I mean, the cops show up and he's sitting there on the front stoop with the rifle that he used to kill his children. I mean, I don't think that's in dispute. His wife and his daughter both gave statements to police about what they say happened. So, is this key in sparing his life? How is this key?
This shouldn't play into the second part of the death penalty case, which is the mitigation phase. What it plays into is, if they can win the motion to suppress, this is just the beginning of what's likely to be an attack on the credibility of the police officers. There is so much evidence that this man did it. Trust me, I'm a prosecutor. I would vote to convict. But jurors are funny. And so if you have a case like this where the evidence is so overwhelming, by building up a case that somehow the officers are sloppy, that could raise, if not reasonable doubt on conviction, it could be enough to get one or two jurors who say, I just don't see going to the death chamber over this.
Let's start with the arguments that Greg Myers and his co-counsel make in this. And you're right, Greg Myers is all over the state of Ohio doing these high-profile death penalty cases for the Ohio Public Defender's Office. The first argument they make is they say that he asked for a lawyer. Basically 6 or 7 minutes into the interview, they read him his rights, but they don't give him the form. He says he understands his rights, yep, but they don't have him sign the waiver or waive his rights. So how important is that? Plus, they say he mentions a lawyer several times, and the cops just keep going with the interview.
Yeah, there's a couple of different issues. Let's try to separate them. So Miranda versus Arizona is the U.S. Supreme Court case that says if you want to use somebody's interrogation that took place in custody against them, you have to warn them about what their rights are under the Constitution. Under Ohio law, and I think it's true in federal law, it's not required to be in writing. It just required that the state can show that there was a Miranda warning, and all the evidence suggests there was a Miranda warning. So that will not be the problem. What I'm interested to hear from the state when they finally file their response to this motion to suppress is what their argument is about this notion that once he mentions he has a lawyer, I think he says it's a family lawyer or it's someone who works for the CIA. It's a little odd. His invoking the lawyer thing. Yeah, I mean, the whole thing is kind of weird, and he's obviously in an agitated state. I will be interested to see what the state says in response, because it is black letter law that when a defendant who's in custody demands to talk to a lawyer, that the questioning must stop. And so I will be interested to see what the state has to say. Remember, there's two sides to every story, but I do know enough about defense counsel that sometimes the way they phrase things in their motions is not exactly the way it happened.
Next argument they make, they say that basically he was being treated in the jail by a social worker and a nurse, and that the police were there at the time, and that anything he said to the social worker and the nurse shouldn't have been within earshot of the cops. So what do you think of that? Any incriminating statements he may have made to these people regarding his mental state or anything like that, the police, the deputies shouldn't have been there with cameras rolling.
Yeah, that's contorting the law of privilege. So all of us, when we go to our doctor, if we tell our doctor something about our medical condition, that there is that doctor-patient privilege, and that can't be introduced against you. But I doubt they'll be introducing what hurts on his body. Information that he would say during that time about what he did during the crime is not part of the doctor-patient privilege because it's not necessary for medical treatment. I think that's a weak argument. I think that's just another thing they're throwing out there to somehow suggest that the law enforcement personnel were sloppy or that they weren't following the rules.
Another thing they say is that they complain that the cops, the deputies, and Claremont County, this is not a urban area. I mean, it's a growing county. It's east of Cincinnati, one county east. So, it's more a little more rural, if you will, but it's become more suburban in some respects. But his attorneys are taking issue with the fact that they called Doerman a monster, and one of the cops apparently on body camera footage said something like, put him in the cruiser or I might shoot the mother effer, something like that. So they're kind of basically saying, like, these cops are a bit of a mess. I mean, what do you make of that argument?
Here's the good news. This is why I love the jury system. You put 12 regular Claremont County residents in the box, and they will say, well, that's normal. They've just arrested a man who all indications are hunted down his children and shot them in front of his wife and the stepdaughter. And that is a normal human reaction. Now, if they didn't follow police procedures, that's a different argument. But the fact that these officers reacted as nearly any other human would do is something that will not offend the jurors at all.
And there's actually, it's redacted in the body camera footage. It's horrible, but you can tell that one of the deputies is tending to one of the children, trying to save the child, which sadly couldn't be done. The final thing that they're arguing, Mark, was the fact that there was a public defender at his initial court appearance who met with him. And of course, the public defender is going to interview him to see if he qualifies for representation and things of that nature. And they say, the deputies are standing there, body cameras rolling while he's being interviewed by counsel. That shouldn't have happened. They're saying his rights have been repeatedly violated. Your thoughts?
Yeah, I don't know it happened that way. Again, I'm interested in hearing what the state has to say. Very good prosecutor's office down there. I have a lot of respect for them. Normally, an attorney-client conversation should not be recorded, and law enforcement personnel should not be there for that. So I'll be interested to hear what they say. Having said that, that should not affect the proof in this case in any way, because there's more than enough evidence out there from before he was in custody that this happened, including the wife and the stepdaughter who will have to testify as to what they saw with what this horrific killer did.
Yeah, he has pleaded not guilty at this point in time, of course. He's going to do that. It'll be interesting to see what the defense in this case is. But, it's an aggravated murder case. They're seeking the death penalty. Trial will begin later this year. So, Mark Weaver, thank you so much for joining us. As always, we appreciate it.
Good to see you again, Angelina.
Okay, well, based on what we heard there, it sounds like maybe the prosecution doesn't have too much to worry about. But then, who knows? Stranger things have happened. So I'm going to jump over and check out this other thing about the idea of having convicted felons serving on the jury.
Doerman was in court today for a motions hearing ahead of his trial, which is set to begin July of next year. It's important to note he is facing the death penalty, which has become a rather complicated issue in Ohio. Scripps News Cincinnati breaks it down for us.
Death penalty cases are different than any other case that you will find in Ohio. Now, it starts normal enough with a jury trial. If you are convicted there, that's where it begins to be unique, because then the jury is asked whether you deserve the death penalty or not. If they say yes, a judge still has to sign off on it. If he says no, you get life in prison instead. But in today's system, even if you get through all of this, it's not clear whether you'd actually be executed at the end of it. Chad Doerman faces the death penalty for executing his 3 boys, 7-year-old Clayton, 4-year-old Hunter, and 3-year-old Chase.
He ripped the child from the mother's arms. Put a bullet in his head.
If convicted and sentenced, Doerman would go to death row. In March, Attorney General Dave Yost called the system broken, as no inmate had been executed since 2018.
I mean, it's still in full effect, and it's still the law in Ohio.
Mark Crumbine has defended capital murder cases for decades and acknowledges the current system has significant issues. Lethal injection, drug shortages, and political opposition has slowed the process.
There could be another governor in the near future that might say, hey, let's speed it up. New drugs that cause people to die, that are more accessible. Some of the problems could end.
Both Governor Mike DeWine and Yost called on the legislature to act. Is there any legislative fix in your eyes?
Well, there probably are some legislative fix. They could, but there again, there's a lot of division. The root of it is there are so many people that are strongly against it and so many people that are strongly for it.
When asked about the delay of executions in Ohio, Tekulve promised to forge ahead.
Let the facts speak for themselves. He slaughtered his 3 children in the most brutal fashion you can imagine.
Now, I've reached out to both the AG's and the governor's office to see if they have a comment. Yost was not available. Dwyne's office did not respond. Sean Delancey, WCPO 9 News.
As we look ahead, Chad Doerman's capital murder trial is set to begin on July 8th of next year. All right, let's bring back in the tank. Al, want you to begin?
Of course, at this point, now that we're in 2024, it will be July of this year.
Darnell Crosslin, and Jennifer Brandt are still with us. And Darnell, I'll start with you. Not all not guilty pleas are alike. He pled not guilty in this case, but got a confession. And the story is pretty much he planned this thing. He executed them. The wife tried to stop him. And so if you want to say you were somewhere else and she tried to stop him, he got rid of her, not killed her, but got her out of the way, continued the killing. Why a not guilty plea in this case? What's the thinking here?
Yeah, so not guilty pleas pro forma. So you're always going to plead not guilty because you can't work it all out in the first moment. So you plead pro forma not guilty, and then your lawyers could either do a change of plea to guilty by reason of mental insanity if that bears out, or whatever other reasons come out. Also, it gives you a chance to look at the discovery. And not have a sentencing. Once you plead guilty, you're staring down the barrel of a sentencing. But you plead not guilty, and you can work things out. You can see if you can get it down to manslaughter. You can negotiate the pleas. A lot of things there. But in terms of the jury here, most places have to have what they call a death penalty certified jury, which means if the juries can't come back with a death verdict, they can't be on the veneer person cannot be on the jury. So if they're death certified, then they go to the second step, and the judge has to find that it's in the court's best interest to certify or to grant the death. So there's different layers to it.
All right, so speaking of that jury, Jennifer Brandt, cases like this, you get tons of paperwork, tons of motions. There's a bunch here that involve, or the ones they were listening to today or entertaining today, involve the jury. One of them, they want the jury pool, this is the defense now, Jennifer, to include convicted felons who have served their sentences. That's a new one on me. Maybe they think they can curry some favor there. I don't know, but what are your thoughts?
I think that's exactly right. I think that they might be someone like that, might be more sympathetic to him. I don't think anyone can understand this crime and understand what happened, but maybe they would, have some sympathy. Maybe somebody he could possibly relate to. We don't know what his story is going to be. He did plead not guilty, so there's some kind of defense that he's going to put up, and we don't know what that might be. But I guess he's looking for people that will be more sympathetic, because most people would not in this situation be very sympathetic for him.
Going to be hard pressed to find someone to be sympathetic to him. Al, what's interesting is there's been this trend in the defense bar to really start taking control of language in court. One of the motions in this case says they want to prohibit the court or anyone involved in the case from using the phrase guilty phase or guilt phase. We hear that all the time in these types of cases. You get the guilt phase, the punishment phase. They feel that's just too suggestive. I think it's an interesting argument.
Well, that is an interesting argument. I mean, it's certainly a better argument than trying to get like Holocaust perpetrators on your jury. I mean, how absurd is that? How do you have somebody on the jury that has been convicted of a crime and that served their sentence? I don't even think they're allowed to be on jury duty, let alone sitting in a jury panel. Okay, so first of all, that's bizarre. But I do agree that suggestive terms can be manipulative, and that language is very, very it can work to your advantage or your disadvantage. I don't necessarily have a problem with that. I don't think that that's a terrible thing. But convicted felons that have served their term on my jury, as I said, I mean, why don't we just put Holocaust perpetrators and, let's go with dictators that got away with it. And those are the guys that we want to have on the jury. And then there'll never be a guilty conviction.
Darnell, convicted felons, they're people too. Should they not have the right to serve on a jury?
Yeah, absolutely. I think so. I'm very much into the whole second chance and criminal justice reform. A lot of states are now giving you automatic exoneration upon your plea. In Connecticut, we hand you a pamphlet right there as you plead, and 5 years from a felony and 3 years from a misdemeanor after your probation is over, you can be restored. And even in New York, they give you what they call a relief from civil disability. Right. So yes, we can't be hypocrites. If people have served their time, they should be able to come back and matriculate into society. And by the way, it's guilt or innocence phase, and then it's the punishment phase. So they're bifurcated. So it depends on what state you're in. You shouldn't have a problem. They say guilt or innocence stage is one part, and then punishment is another part. And they tell the juries you should not be concerned about punishment. Only render your verdict here. And the court normally deals with sentencing.
All right, fair enough. And I can tell you, if you let the convicted felons into that jury room, it should make for some interesting deliberations. All right.
Okay, so I ended up finding the other video that talks about his attire and not being in shackles.
I want to bring in right now long crime correspondent and host of Crime Fix, Anjanette Levy, to talk a little bit more about the biggest updates from this week's motions hearing. Anjanette, good to see you. First, let me just start off before we even get into the motions. My understanding is you know about this area and some of the players, right?
Yeah, I live in Ohio, and I do know some of the players in this case, Jesse, and thanks for having me. This is a horrible case. I mean, we cover so many crimes here on Law and Crime that are just absolutely disturbing. This one boggles the mind. Anytime we cover these cases where parents kill their children, it's so hard for all of us to wrap our heads around this, especially this one, since Chad Doerman was planning this for months. That is what he told detectives. For many months, he was plotting this out. And these are defenseless, helpless little boys that he was supposed to be loving and taking care of. As a parent, it's your job to protect your kids. And he was not doing that. Yes, he has pleaded not guilty. But I think it's quite clear from the evidence that we have, he did it. Just exactly what his defense will be, it has not yet been made clear to us.
Yeah, and I 100% agree with you. Cover murders and the worst kinds of crimes every day, but it's the ones against children that, I don't know, for me, they're the ones that resonate the most, they're the ones that are most difficult to shake, the ones maybe hardest to understand. Now, just to be clear, before we get to what happened in the hearing, we have not gotten any more information about a motive, right? That hasn't been identified by prosecutors?
You know, I think this is just something he said he had been plotting for a long time. I think this is somebody who's really disturbed. And to think that he was sitting around for months and thinking, this is what I'm going to do, and I am going to do this, is just beyond the pale. So
yep.
Not exactly 100% clear on that motive, other than this is something he wanted to do. And, think about the mother in this case. She's sitting there watching her children be slaughtered. She's obviously trying to do something to protect them, and she gets hit with a bullet. So this is a guy who's got a lot of rage, quite obviously.
It's unthinkable and it's unimaginable, to say the least. My understanding, though, with respect to the legal case, is that there were more than 24 motions that the judge is looking through, filed by both by the prosecutors and the defense. And my understanding is that the judge hasn't officially ruled on any of them yet, but we are learning a little bit more about them. And Jeanette, talk to us about, first, what Doerman is trying to argue he should be able to wear and not wear in court.
Well, he doesn't want to wear restraints. And we see that that's a pretty common thing in cases where he should not have to wear restraints in front of the jury. And I think that we can agree that that's probably something that he should be allowed, the judge should permit that. When there's a jury in the room, he should be able to appear without restraints. A lot of times, the defense attorneys will argue that even pre-trial, they should appear without restraints because those images go out on the news and people see them. He was in street clothes yesterday, and, he's got the, little belt with the shackles and the handcuffs and all of that stuff. the judge said in court that, look, I'm hearing he's been a model citizen in jail. He's not been a behavioral issue for the people in the jail. He's behaved. I think it's interesting because a lot of times we see people accused of heinous crimes. Once they get into this institutionalized environment, they are model inmates. Maybe that's what they need. I don't know. He could be receiving medication. I don't know. I'm assuming he may have some mental health issues. So there are a lot of things probably going on that we're not privy to. But he wants to appear in street clothes and not wear restraints. And this is not surprising to me because his lawyer, Greg Myers, is somebody I've kind of been in contact with or known sort of through the court system for a while, because he represents and has represented a lot of people accused of very heinous crimes, including Jake Wagner in the Pike County Massacre. So,
just curious, did any of you all follow the Pike County Massacre? I just recently watched a lot of it, and that is, wow. Just curious to know. That's my problem. I watch so many of these things, like the Adelson trial and the Crumbleys, but the problem is I know I can't possibly cover all of them, so it's really hard. But just curious to know if any of y'all had followed that.
this is a guy who's been around the block. He knows what he's doing. He's like the chief trial counsel with the Ohio Public Defender's Office, and he routinely files motions such as these when he's representing a client saying, my guy shouldn't be seen in these restraints because you're going to paint a really bad picture of him in front of the jury. So a lot of times what they'll do, and I know what they did in the Pike County case, they have this like vest that they put on them, and they put it on underneath their clothes, and if they get out of line or do anything wrong or pose a harm or a threat to the public in the courtroom, they can zap them. And all these volts go in there. There was another case that we covered here on Law and Crime, Anthony Kirkland. He was a big behavior problem in the jail. He's nuts. I mean, the guy,
I remember that one.
I remember that one. Horrible little girl. He was a horrible person. Like, he's just the worst of the worst. And they had this belt that they put on him because there were times they had to strap him to like a gurney and wheel him into court. We were like, what the heck? Like, literally he's like strapped into this like restraint chair. And so they had a thing on him. And I remember the judge, Pat Dinkellocker, said to him during the sentencing hearing, he's like, you're going to sign this piece of paper basically saying, you know, that you've got a thing on your leg, and if you basically are out of line or you try to act up in this courtroom, the deputies can zap you, and it's going to be like 80,000 volts or something crazy going into your body, and you'll probably defecate and urinate yourself right here in the courtroom. So, wow. I mean, there are a lot of things they can do to ensure that the prisoner or the inmate is not seen in restraints in front of a jury. And those are two of the things, the vest and the stun cuff bracelet thing on the leg.
Yeah, and just to, explain a little bit more what you said about what the judge said here, he was quoted saying Mr. Doerman has not been disruptive in any fashion at the county jail. He's not caused any problems. He's been in the courtroom twice and has been very compliant. That will weigh in on the methods of restraint that I will consider an issue at this time. By the way, Anjanette, you covered Pike County? Didn't know that.
You should say that's an inside joke to all of us around here.
Listen,
so I don't.
Anjanette, if it wasn't for Anjanette, we wouldn't probably have known about Pike County. We would have gotten all the details. It was Anjanette's case. I like to tease her about it because that was yours. That was the one you covered.
Yeah, there's a behind the scenes thing that goes on with this. So we'll just say all I have to say are two words: Sam Goldberg. Enough said. All right, and we'll leave it at that.
All right, so there was another big issue about jury selection. Who's going to be selected? What questions they're going to be asked? What did we know about that?
Yeah, so Jesse, the defense is asking for a couple of different things here. They want individual voir dire. That means you have all these jurors sitting around. Maybe they bring several hundred of them in, and instead of just kind of throwing them in the box and doing things the way they normally do, they bring in each juror individually. And really, I mean, for this case, there's going to be an added layer of jury selection anyway, because this is a death penalty case. So they will have to have what's called death qualified jurors. So before you even get to jury selection, they're going to have to whittle a pool down to maybe like 100 people, 100 jurors, potential jurors who have been questioned and who've said, I can, even if I don't like the death penalty, I'm morally against it, I can follow the law and impose it if I see that it's warranted in this case and that the state has proven the elements for the death penalty. So they want them questioned individually. I don't think that that's unusual. We saw that as well in the Pike County case. At least in George Wagner's trial, they brought the jurors all in individually. They interview them. It takes maybe like 20 minutes a person, sometimes longer if issues arise. They also want people who maybe have been convicted felons and served their time to be on the jury. Typically, you don't see something like that. And I'm going to say this because a lot of times they don't want convicted felons on juries. And there was one case here in Kentucky, actually, where Shayna Hubers, you probably remember that case, her conviction was vacated and she got a new trial. She got a second trial because one of the jurors didn't disclose that he had a felony conviction on his record. It was like something about child support or something. So she got a new trial for that. It didn't work out very well for her in the end because she got a heavier sentence. But, a lot of times they'll frown upon that and they don't want people who have had criminal records on the jury. But I think that you could see like a defense attorney thinking, you know what, there's somebody who's done some time and they should be able to serve as a juror. And maybe this is somebody who can understand where we're going to be going with our case because they've been through the system.
Yeah, a couple of things there, right? So traditionally, like you said, felons wouldn't be able to sit on a jury. The Ohio law actually provides a way that you can restore those rights. And I would imagine for the defense here, they're probably saying, well, these are people who committed really bad crimes. They served their time. Maybe they'll have a bit of sympathy for somebody in Chad Doerman's position. I mean, again, he's accused of murdering his children. Not sure that's the best avenue, but I don't think personally I've ever heard that before. Thought it was an interesting motion. We'll see which way the
I think that's probably a
judge
new
decides.
thing. Don't you feel like that's kind of like some kind of new thing that maybe that's like kind of making the rounds and like the public defender and defense attorney?
I haven't heard it.
Circles.
I haven't heard it. This is the first time I've heard it. The idea that you wanted convicted felons on.
Yeah, I can tell you, Mark Ticalvi, the prosecutor in this case, the elected prosecutor, he wants Chad Doerman put to death. He has made no bones about that. I mean, Mark Ticalvi, I actually have known him for many years. I haven't talked to him in a long time, but I can just tell he is all business and, well, this is a heinous case. Yeah,
this is what he said. He goes, quote, "This is a death penalty case, and my goal is to have this man executed for slaughtering these 3 little boys."
Yeah, I mean that's what he wants. So you know what the defense is trying to do here? It just kind of popped into my head. They're going to have a tough road to hoe here, and Jesse, I really think that what they're looking for is maybe one juror who in the mitigation phase is going to say, they're going to be that one juror who's going to say, we need to give him life and not send him to, lethal injection or whatever.
So it would be interesting. It would be interesting if you have somebody who served time in prison, knows how bad it is, and saying, listen, I think he should go to prison for the rest of his life. That should be his punishment. I don't know. We're probably guessing here. But I just thought it was interesting to say the least.
I think that's where they're going with it, don't you? They're like, we need somebody who could be on our side.
I think it's also the sympathy factor. Like, these are people who committed heinous crimes. They might understand where he was coming from, but it could definitely be for the mitigation part. I don't disagree with you. I mean, the death penalty aspect does change a lot of the factors in this case, so I would agree with you. I think it's probably more for the mitigation than the guilt part. By the way, little side issue to talk about that. Not sure if you're aware of this, but one of the motions that the defense filed is they want to prohibit any reference to the trial phase. So the first part of this, they don't want any reference to it as the guilty phase. They don't want jurors hearing it as the guilt phase, which, again, pretty unique motion because that is essentially what it is. You have to determine if he committed these crimes before you can determine whether or not he should be executed.
And I've seen Greg Myers file this motion in the past. So I think that there are a lot of motions that were argued yesterday. I think there were 41. A lot of these were probably boilerplate motions that are out there. I know I've been on the Ohio Public Defender's website in the past and gone through the boilerplate motions that they have posted on there. And I think a lot of people just take those and then they add their own stuff. There's like a template and then they add their own arguments or briefs or whatever to these things. So that does not surprise me at all. I think that's a pretty common thing. And I've seen that in some death penalty cases in Ohio because they're trying to like soften the language.
Right.
So that you don't just go in, oh, the guilt phase, well, must be guilty,
Right.
You're kind of conveying a different message about the system to these jurors.
Mm-hmm. I can understand that. There was one other big issue we want to talk about. The motion concerning all of the photos and videos of the crime scene. What can you tell us about that?
Well, they don't want anything that's really, really graphic to be seen in front of the jury. And I think this is a pretty common motion that defense attorneys in Ohio file as well, especially in cases where you have something so heinous. And, all murders are horrible, but this in particular is really heinous. I mean, these are children. So I am sure that the crime scene photos and videos in this case are horrific. I am sure that Greg Myers is going to want to minimize as much as he can those really graphic crime scene photos. So maybe you show one that's a wider shot, or maybe you show one that's this. I'm sure the prosecutor is going to say, look, we have to show these because it's going to the premeditation factor or the whatever, because with aggravated murder, there are different elements and premeditation can be one of those elements. The fact that these were kids, that's another element as well. But they're going to want to show the jury some really, I'm sure, and maybe in the penalty phase as well, photographs that show just how bad and how brutal this was.
Well, we also have to
So,
remember that
I don't think it's
prosecutors have to prove their case that a murder was committed and was committed, by gunshots. So sometimes you have to show those photos just to prove the essential elements of the case that this was murder. And those photos, and I think there's 350 photos and videos in this case, some of them are going to be necessary for the jury to see.
Oh, most certainly, because if you have like the lead detective who's going to be on this, or maybe the first deputy who arrived on the scene and he goes in the house to see if anybody can be helped, there's probably body camera footage of really terrible things that are going to be shown. And that deputy or whomever was the first to enter that crime scene, they're going to have to say, this is how the investigation unfolded. We get there, guys sitting on the porch with a rifle, and then we walk into the house and we saw these little boys in the condition that they were. So they have to show that stuff. But I'm sure there are some things in there that Greg Myers would rather the jury didn't see. And so this is not uncommon for a defense attorney to ask for something like this. He may not get it, but
Right. Yeah.
You have to ask.
And I believe the judge had said, look, in these types of cases, you categorize them. So there are non-gruesome images and videos, there are not particularly gruesome, and then they're gruesome. And that might be a way that you can separate everything out and try to make sense of it. As of right now, Doerman being held at the Claremont County Jail on a $20 million bond. His trial date is scheduled for July 8th, 2024. And we will see if that date sticks or it will be moved. And Jeanette Levy, thank you so much for coming on. Everybody check out Crime Fix. And if I don't see you, happy Thanksgiving. Great scene.
Well, that was some interesting things we learned. What do y'all think about convicted felons that have been released serving? I guess it would depend on what they did, but I mean, if a lot of those people didn't do something like that, they probably still aren't going to like him. I don't know. It's hard to say. It's just that's just nuts that now he wants to toss the confession. I think that's going to be hard. And then as far as the photographs and videos, I know that would be awful, but it could be, let's say maybe one of the jurors is on the fence. They see the photos and see the horrific, I guess is one of the best words to describe it. The horrific aftermath of what Chad did to those little boys. It might really make them say, oh, wait a minute, because now it's just nuts. Well, I guess he's getting to wear his clothes. It's so hard for me to not be so biased. Well, obviously, since we know he did do it, but to him to be able to still make decisions and have requests like, I want to wear street clothes to court and no restraints while I'm there, while the poor mother and stepdaughter are never going to be the same, and those cute, darling little boys don't get to ask for anything because they're no longer here. That's what's hard for me. I have no idea why I chose this case. I typically probably wouldn't have, but then I saw it from the beginning, and now I feel like I've got to see it through. But I'm like, oh my gosh, what was I thinking? But, hopefully we can see justice. What is justice, though? Once you've lost someone, but, they always say for something to follow through in the victim's favor does help give the family some closure. So let's hope that's it. And I just want to know, why the heck didn't they have something up under a vest for Darrell so he could be zapped? Because it seemed like there could have been many zappable moments for him. Of course, he allegedly said, which of course was debunked by the judge, that he had his shock shackles. But it would have been nice if he'd had that under a vest. Why didn't they do that? I don't know. Maybe, you know what, though? Maybe it differs from state to state. Could be. All right. Well, that is the latest update on Chad Doerman. And it sounds like they said his trial is set, as of right now anyhow, for July 8th of this year. So we'll see how that progresses, if there's any changes or anything like that. And I hope you enjoyed it. I mean, this is hard to enjoy, but, you found at least the information helpful as we proceed through this unthinkable, dreadful situation. Okay. Well, as always, thank you so much for watching, subscribing, commenting. If you haven't yet subscribed, please subscribe, because it doesn't cost a thing. And so you know what to do. Be kind to one another. Be kind to you. I love you all, and I'll see you the next time.